everyone, it's Tracey McMillan, and today I'm going to do a webinar for you on divorce. So, some of the questions the judges are going to ask you in a divorce application is this: when did you separate? Okay, so they're going to ask you those things. When did you separate? Possibly how you communicated that separation. Was it your intention of both parties? So you outline your heading. When did I separate? How? What occurred? The next one is the court's going to want to know that you have been separated for 1 year and 1 day. I like to make it really easy for a judge. So when I get into court, I want to tell them everything that they want to hear, which is already in the application. And I know what you're saying or probably thinking, but it's already there in the application. But if you're one of 20 matters that are before them, do you think they really want to go through and read every single application that's before them? Or do you think that they'd rather someone tell them so as they make it easier for them and quicker for them to make a decision? They're also going to ask, well, has the relationship broken down irretrievably? And what arrangements are in place for the children? So if you have separated, then I would recommend you do something along the lines of this. Good morning, Your Honour. My name is Tracey McMillan. I am representing myself. I have a divorce application before you. Your Honour, me and my partner, my spouse, separated on the 1st of May 2019. It has been a year and a day since that separation has occurred. The application was filed in June of 15th of June 2020. Thereafter, there has been a year and a day prior to the application being filed. Your Honour, the marriage has broken down irretrievably and there are no prospects of the relationship being reignited. Your Honour, there are 3 children under the ages of 18. Arrangements have been made for the children. We have a parenting plan in place which is attached to my application. Now, if you have been separated under one roof, you might say, Your Honour, I have filed an affidavit dated the 10th or 15th of June 2020, affidavit of Tracey McMillan, and that goes to outlining the arrangements for the children. In summary, the children live with me on a 2-week basis for the first week from 9 a.m. Monday until 9 a.m. the following Monday. My spouse and I have half of all school holidays, and the children are currently attending Pine River State High School and are progressing well. There are no health matters in relation to the children. So if you can see with what I just did for you then, is I basically just told the judge exactly what's in my application without them needing to go through it all. A judge would be very grateful for that, and it means they can get through their matter quickly. So if you can do that, by all means do it. If you can't, that is fine. It is there in the application. They're used to people turning out without it. But try and make it nice and succinct for you. The other thing the court is going to want to know is, when did you serve the application? If you're representing yourself, if you filed yourself, when did you serve the absolute application? So then, if the judge, or it could be a registrar, by the way, it's either or, just refer to them as Your Honour. But either way, hopefully, fingers crossed, there'll be no hiccups and they'll make the order. If there is a hiccup, they'll usually adjourn it off and ask you to do certain things and then come back the next day. So, great. The court will then say something along the lines of, I refer to the application filed on the 15th of June for a divorce 2020. I refer to the affidavit of blah. They might reference I read the affidavit. That is just a technical legal term. They will go through all the documents and the service documents, and they will say things like, I am satisfied that the parties have been separated for a year and a day. I'm satisfied that the court has jurisdiction to hear this matter. I'm satisfied that the relationship has broken down irretrievably and there are no prospects of the resumption of cohabitation. Court will then say, based upon those issues, I find that the court will grant the application for a divorce. Now, that doesn't mean that you have your divorce. What it is the court will grant you something called a decree nisi. So if you get any paperwork back in that time, you might see at the top of it, decree nisi, which is NISI. What that means is that your divorce will not be final until until that order has been in place for 28 days. So it's 1 month basically. So 1 month from that time, and only after a month has lapsed, will that divorce be called or changed to a decree absolute, and then your divorce certificate is issued. And it is that date which is your date of divorce. The reason of the 28 days is there, to put into context, is so that if somebody does not agree with what order was made by the court, they can appeal it. So there's always that room. It's very rare that it ever occurs. It's only in the most complex of matters. And for most people, it's just merely a procedural thing. So it's 1 month after that date that it will become final. When that happens, then ComCourts will upload your divorce certificate. And then, ladies and gentlemen, you have your divorce and you can now go on and get remarried if you in fact choose. So that is what the process is. If you have that divorce certificate, I just want to stress, keep it in a safe place because you're going to need it if you ever do decide to get remarried or for other random things. So it's actually absolutely important. If you lose it for some reason, you can jump back onto ComCourts and download another copy of it. That's perfectly fine. So it's important to remember, and I just want to stress finally, one last thing. Once you've issued your divorce, you got your certificate, you're like, woohoo, home and host. I just stress this. If you have not gone through and divided your assets yet, you now have 1 year to have either divided it and got a consent order or a binding financial agreement in place to figure out who's keeping what, or 1 year to have filed in the court, the family court, for an application to go through and divide your assets. If you do not do it, then you are now statute barred, which means the court will prevent you from bringing any application to divide your assets unless you can prove an exception or a reasonable excuse as to why you did not comply with that time limit. That adds time, that adds money, and that adds complexity. So don't do it. So put it big, bold, on your fridge, in your diary, anywhere to make sure that you actually go through and do it.